Everybody's on there. Claudia's not hooking up. You have to listen from where you are. Oh, you're on. Okay. All right. This is 003-1050-2021. It's Unifund CCR LLC versus Michelle Burns. Probably I'll start with who you are and who you represent. Can y'all hear me?
Your Honor, I'm Tim Elder. I represent Unifund CCR LLC, the plaintiff.
Okay.
I am Michelle Burns. I'm a pro se defendant.
Gotcha. Okay. And we're here on a defendant's motion for a new trial after we entered a default judgment back, I guess, a month or so ago. It's your defendant's motion, so you can start. I've read everything. I've read what happened. Looked like you thought you filed an answer, but you didn't because of the e-filing system.
Yes, Your Honor.
And the plaintiff's response basically alleges that even though that may have been an accident mistake or that would lead to possibly a new trial, you did not set up a meritorious defense or address the issue that it wouldn't cause them harm.
Yeah, I apologize. I didn't know that I was supposed to address all three of them. I thought I was just supposed to address one of them. I mean, it was just a mistake on my part. I mean, I've had a couple of these. Unfortunately, many years ago, my ex-husband got behind and quit paying child support. So I ended up with a bit of credit card debt. So I've had a couple of these, and I went to file the answer the way I did previously, and it just didn't thoroughly submit. And then I don't know why, I just got a gut feeling to check on the case. I was told that I could, check the case online, and I checked online on the 11th, and I saw what had happened. So, that's what I was trying to remedy. All I am hoping for, and I did read the plaintiff's response as far as not meeting those three, and then as far as not filing, an answer with it, I thought I had to wait to file an answer after you either approved or denied the new trial. Basically, all I would like is a chance to try to mediate this and come to some sort of agreement that both the plaintiff and I can live with. And that's all that's my end goal. I don't want to, take this to trial. I don't want to do any of those things that would cause the plaintiff to have added expense. I would just like a chance to try to come to some sort of arrangement on this.
Does the plaintiff have a response?
Yes, Your Honor. Addressing the last first, we certainly have no problem with entering into some sort of negotiations, and if something can be reached, that's fine, well and good. However, the defendant has chosen to act for herself, and unfortunately, she's got to be held to the same standard as a party with an attorney. a motion for new trial does require that she meet all three of the prongs of Craddock, all three of the Craddock elements. And there's been no attempt to file an answer otherwise. And since the defendant is not an attorney, she has other options available to her that aren't available to members of the bar for filing documents. So she could have filed them in other by other means than by e-filing. Otherwise, Your Honor, you've read my deathless prose, and that says pretty much everything I need to say.
Well,
Your
I
Honor?
mean, yes, ma'am.
I have a quick question. One, I didn't think I'd asked for a new trial. I thought I'd just asked that you.
It's
Over-
the same thing.
Oh, it's the same thing?
It's the same thing.
Oh, well, okay.
Just that.
I guess I was confused because the way the filing fees worked.
Setting aside a judgment is the same thing as asking for a new trial, because you technically had a trial when the default was entered. So
Oh,
it's just a technicality. But
oh,
the plaintiffs are right. They do have the right to the judgment, and you didn't set up the defense the way you're supposed to. So I can't really set aside the judgment. It won't stop you from working out something with them. So you have their phone number. I'm assuming you can call Mr. Elder and try and work something out with him, with the understanding that if you can't get it worked out, there's still going to be a judgment out there that you'll have to deal with.
okay.
Okay.
Okay. And then as far as filing the answer another way, it was my understanding the courthouse wasn't open. Like the clerk's office, you couldn't just walk
Yeah, you could have.
it was back in March.
Yeah, you could have. They were allowing pro se people to actually file stuff in person.
Oh, I'm sorry. This whole thing has just been a nightmare and trying to figure all this
understand.
out. So
Anyway,
I'm sorry, Your Honor. I didn't mean to waste your time. I'm sorry, Your Honor.
It's okay. But the plaintiffs or the defense motion for new trial is going to be denied, and I'll sign that order when I see it. And I hope y'all can work things out. All right.
Thank you,
Thank
Your
you.
Honor.
Good luck. Thank
Your
you.
Honor, I believe an
Yes.
order was e-filed. If not, I'll go and kick my daughter who's.
There's one need filed. I'll get it signed today.
And if I can have just a moment, Your Honor,
Sure.
to communicate my direct line to Ms. Burns.
Just one moment while I get to where I can type it in. Okay, I'm ready, sir.
972-367-4475.
And that's your direct line, Mr. Elder?
It's right here on my desk.
Okay, thank you, Mr. Elder.
Yes, ma'am. Thank you, Your
Good
Honor.
luck. Thank y'all.
Maybe